Good afternoon, everyone. Allison Scobber here, Consolidated Planning Group. Welcome back if you're joining us again for another webinar. And if you're here for the first time, welcome. We are certainly glad that you are here. Again, I am Allison Scobber, owner of Consolidated Planning Group. We are a holistic special needs financial planning firm, nationally certified as Social Security advisors, members of the Special Needs Planning Academy, and chartered special needs consultants. I'm also a parent to adult kids, plural, with disabilities. So we have a webinar series. We meet usually 2 or 3 times a week. We have webinars on topics pertaining to planning for your loved one with a disability. And today we are super happy to be back with the Weeks Law Firm and attorney Rachel Dickison. And she's going to take a deep dive today in wills, special needs trust and guardianship. I always like to go through the housekeeping items. We did get several write-in questions. So if you sent your question in ahead of time, we do have that and we are going to go over that. From a perspective of today, we can't see you. We are in webinar mode, and so we can't see you or hear you, but we know you're there. And we do invite you to put your questions in the chat box if you have additional questions that you didn't send in or throughout the presentation, and we'll get to as many questions as we can during the time that we have together today. We're going for about an hour today, and everybody is going to get an email later this afternoon with a link to the recording so you can listen to it again if you need to, and a copy of today's slides. So I just like to tell people that because you don't have to write everything down you hear and see today, because you actually are going to get a copy of the slides for your benefit as well. So from a perspective of kind of what we do versus what the Weeks Law Firm does and what Rachel herself does, I always like shorten that up by saying that they're the paper and we're the money. They're the legal documents. We don't do what they do and they don't do what we do. So when it comes to planning for special needs, it is really our recommendation that you work with a specialist that is specifically nuanced for individuals with disabilities, because sometimes when you work with other professionals that are not nuanced with special needs, then sometimes the setup that you have, the documents that they have, they could be incorrect, and it could be the difference of maintaining public benefits or losing said benefits. So I think that that's really important. One of the things that Rachel's going to be talking about today is, some of the places that we can have money above and beyond that $2,000 limit for Medicaid, and that's going to be a special needs trust or an ABLE account. So we're going to take a deeper dive in that and kind of weave our way through of how you can preserve your eligibility for state and federally funded programs. We help people put the protection plans in place, the lifetime care plans. We do a lot of transition planning. We help set up ABLE accounts, which is another account. It's different than a special needs trust that you can have money above and beyond $2,000. And we do a lot of advocacy by way of our webinars. So having said that, I want to get right into our contact today. Welcome, Rachel. Thank you for being back with us today, and I'm going to let you take it away.
Wonderful. Thank you so much. So we're going to be covering a variety of topics, just like Allison said. I'm going to give a general overview of those topics. There's a lot of great webinars on some specific deep dives, but I'll try and get to your questions as I have the ability to. All right, next slide, please. Thank you. So generally, what is estate planning? Everyone hears this term, but they don't know exactly what that means. Really, it's what happens to your property if you become incapacitated or if you pass away. So we're setting up a plan for if you become disabled yourself or after you pass away, who gets your money, how do they get it, and when do you want them to get it? If you don't make a plan yourself, then the state is going to set up a plan for you, and that's not necessarily what you would want. So we're really looking at everything, a broad stroke of what you want your estate plan to look like. Next slide, please. So this is really important with families for special needs children because of government benefits. So we want to make sure that we're maximizing government benefits for your child's future. but also planning for your own incapacity. What's going to happen during your lifetime to your child, and what's going to happen after you pass away, making sure that someone is going to be there to help take care of your child and figuring out who that right person would be. Now, we do this through a variety of documents. The big one you've probably heard of before is a will. So that will sets up what happens with your property after you pass away. Then we also have a special needs trust. I'm going to be getting a little bit more into this in just a minute, but this is what happens with the money that's designated for your child with special needs. Then we also recommend, as part of this process, you're designating a guardian for your child with disabilities and for yourself. So what happens if you are unable to care for your child with disabilities or care for yourself? Who's going to be that caregiver for you? The other really important thing that we need to look at is a holistic plan. So we need to look at your beneficiary designations and really how that money is getting into your will, how it's getting to your special needs trust. We also want to coordinate with all of your other family members, making sure that anything that they do is not going to disqualify them from government benefits, and then making sure that you have powers of attorney set up, again, for your own incapacity, but it's also helpful even if you're not incapacitated to handle different things.
Rachel, I cannot say enough about the beneficiary designations, and I know you know this because that's kind of, you guys talk about that, and we usually do the forms to change the beneficiaries. And so often, so many times, every webinar we do, the beneficiary designations are a little wrong, right? Because a lot of times what people do is they make their spouse the beneficiary, and if I die, my spouse is already dead and gone, then that's easy. I'll just divide it equally amongst my children, and they name the individual with the disability outright as opposed to it going to the special needs trust for the benefit of said person. And so I always just like to say this is super important. So if you are taking notes today, write down check beneficiaries. And when you're writing this down, I'm talking about life insurance at work, life insurance outside of work, 401ks, 403bs, annuities, bank accounts. There's so many things that we could have named accidentally a person. And then when you said coordinating with other family members, that's a big deal because a lot of our parents and grandparents, they keep their cards close to their chest. They don't always tell us what they're doing and they want to help. And they just go to their financial advisor. Their financial advisor doesn't have any background in special needs, and then they accidentally name your child with disabilities as a direct beneficiary as opposed to the special needs trust. So I just want to reiterate how important these intentional conversations are and how important it is to check your beneficiaries. Now, if your beneficiaries are wrong, don't freak out. It's a change of beneficiary form. Now, if you don't have a special needs trust set up, then of course you would have the expense of setting up a special needs trust. But it costs nothing to change your beneficiaries. It's a simple form and you can get this fixed easily. So I always just want to tell people not to panic that there is an easy fix for that.
Definitely. And also on the beneficiary designations, I have clients come in, we're reviewing their plan. They worked with me 5 years ago. We go through all their beneficiary designations and we find one. So even if you've looked at this before, it's good and important to check that, even if you think you have everything right. All
Well,
right.
and one more thing on that, because sometimes people think that because they've done like estate planning with you and they've set up a will and they identified in the will who gets everything, quote unquote. But the thing is what people have to understand is designation, beneficiary designations on life insurance, bank accounts, investment accounts, annuities. Those beneficiary designations trump everything that's in the will. So even though you said everything goes to such and such, if you didn't get those beneficiaries changed, it's not changed. And I think that there's a lot of misconception out there that once I check that off the list and I work with an attorney and I get that document, then the rest is done. So I just want to mention that as well.
Definitely. Thank you. So we're going to talk a little bit about government benefits. Again, there's great webinars talking about all of this in depth, but this is just to give you a general overview before we talk about special needs trusts. So the main government benefits that are available for individuals with special needs Our SSI, or Supplemental Security Income, this year the amount is $967 per month used for food and shelter. And there's also Medicaid. So I'm going to get into this a little bit, but if you have $1 of SSI in Texas, you will also have Medicaid coverage. You may have also heard of Medicaid waiver programs. These programs are different than traditional Medicaid. So there's a wait list for those programs. Those programs give you attendant care, respite care, potentially residential care, different supplies. They all are a little bit different. If you have not heard of these waiver lists before, maybe some words like home and community-based services, class, MDCP, anything like that, if that doesn't sound familiar to you, I strongly recommend that you look into this and get your child on the Medicaid waiver list as soon as possible. Next slide, please. So for SSI and Medicaid, there's 3 general requirements. One is a disability determination from the Social Security Administration, and then you also have to have low income and limited resources. When I say low income and limited resources, I'm generally talking about less than $2,000 of each. Now the Medicaid waiver programs, those all have different requirements. It depends on the program itself. Next slide, please. And for income, so income I say is less than $2,000. For SSI, they cannot be earning more by working than $1,620. That amount does change every single year, but that's this year's amount. Now, income is food, shelter, cash, or anything that can be converted to shelter. During your child, whenever they're in their childhood under age 18, your income as a parent or whoever the caregiver is will be deemed to that child. Once they turn 18, they will be considered to be their own household, and it'll be their income that's considered to be under $2,000 limit. As I mentioned before, $1 of SSI means you have Medicaid eligibility in Texas.
Rachel, I just wanted to mention that in October of last year, they struck food. So they determined that they really weren't going to count the food anymore, but forever they were counting food and shelter. So that was a good update with the Social Security Administration.
Yes, definitely. On the next slide, there you go, perfect. So yeah, that's a great point. The rules did change near October of last year. So if someone else provides, it used to be food and shelter. If someone else provides food and shelter to that individual, then it would count against them. It would still be considered as part of that income, not the child earning it, but someone else is providing for it, usually a parent. As of around October of last year, it changed to be only shelter. So if someone else is providing the house that that child's living in, they're having to live rent-free, then they would have a reduction in the total amount of SSI. That would be a 1/3 reduction in the SSI amount. Now there's ways to get the full amount even if someone else is providing for shelter. One of those big ones that people use is running through an ABLE account or paying rent. So the person with a disability pays rent to the person that's providing the income.
We have one person in the chat box that says, I've been told income limit is 2,900 per month, asset limit is $2,000. That income limit, I think it's 2,901, and that's for Medicaid waivers. There's an income limit for Medicaid waivers, and that's 2,901, but the asset limit is still 2,000. And she asked, has that changed? And the truth is, no, it hasn't changed. There's been some proposed legislation to raise that amount. We've heard different amounts, 10,000 sticks to mind, but it's never passed. So it still is the $2,000, but the income limit and the asset limits are two different things. And we can start confusing programs, like when you're throwing in those Medicaid waivers, but that 2,901 is 300% of SSI. So whatever SSI is, it's 300%. So 3 times 967 comes to the 29, I think it's 2,901. is that number. So I just wanted to mention that.
All right, on the next slide, we're going to talk about resources. So remember the 3 requirements: disability determination, low income, low resources. Resources is the actual money that you have in your name. So less than $1,000 in countable resources. What is not counted is a home, a car, personal items, or 529 education accounts. Those do not count against your child. What is counted against them is just typical bank accounts, uniform transfer to minor accounts if they're under age, or excuse me, if they're over age 21, investments or real estate. If it is over the $2,000 limit, it will count against them for SSI purposes. Next slide, please. All right, so whenever there's another program that your child may be on or may be eligible on for the future, I call it disabled adult child. This happens whenever a parent passes away or whenever they start taking their Social Security retirement. So if a child is disabled prior to age 22, they may be eligible for this program. They can receive about half of their parents' Social Security check that they're getting from their Social Security retirement. And then after 2 years of being on that program, they will also be eligible for Medicare. Now, if your child's on a Medicaid waiver or they also still need that Medicaid eligibility, they still can reach that limit. However, they have to be under the resource requirement for SSI. So they still have to meet those requirements for Medicaid if they want to have Medicaid and Medicare. Next slide, please. Now,
Can we just talk about that for a second? I want to go back because this is really an important point. When we were talking about that dual eligibility, they were getting SSI and Medicaid first, and then later on, the parents turn on their Social Security, and then they're eligible for DAC benefits, disabled adult child, now called childhood disability benefits. And then after 24 months, they're eligible for Medicare. And I think I just want to talk about a little misnomer that floats around in our community. And it is that when your child switches over from SSI to the STAC benefit or childhood disability benefits, that it no longer matters, like that asset limit, that $2,000. And that is true for that program in itself. However, if you still want to be Medicaid qualified and you still are interested in a Medicaid waiver, which require Medicaid qualifications, you'll always have to follow the Medicaid asset limit. And so I think around the water cooler, Rachel, people hear it doesn't matter anymore, and then they accidentally mess up a Medicaid waiver that they've been waiting 17 years for, and it's a really big deal. So I think it's worth mentioning that.
100%. And something that I think is really important and how we like to plan is we want to keep all your options open. So having a special needs trust, if they need that Medicaid eligibility, they need that Medicaid waiver, then it keeps that option open for them. Maybe they don't need that. Maybe they just need the Medicare, not Medicaid coverage, but it allows them to have that ability in the future. And that's something that we are a big fan of. We want to make sure every option, every door is open for your child with disabilities. Now, generally, what a special needs trust is great for is that it is not a countable resource. So if it's properly drafted and then it's correctly distributed, then it will not count against your child for government benefit purposes for resource limits. I will also, the distributions from the trust are not considered to be income if they're done correctly. So what this means is that a special needs trust does not break the resource limit. It's not a countable resource. And the income coming from the trust is not going to count against them. So they're still going to be eligible for government benefits. And still they can have this money in a special needs trust for them. Next slide, please. There's generally, I believe there's two, I think that's the next slide. There's two, oh, okay. So there's, what is a trust? A lot of people will hear this term, you don't know what that means. Generally, a trust is a legal document that sets out the people that are there that are going to be managing the money for your child, but also who's going to be caregiving for your child, setting up where the money is coming from and how it's going to be distributed out. And generally, it's providing a safety net for your child. So that's generally what we're looking at when we say a trust. It can be inside a will, it can be a standalone trust, depending on your situation. An attorney could recommend either way.
We have a few questions in the chat box before we get too far away from. I know this presentation isn't like solely on SSI and Medicaid, but there's always so many questions with that. And to Rachel's point, we do have an entire presentation, multiple presentations about that. It is confusing. One thing I want to make clear when they're talking about these asset limits, if the child that is disabled is under age 18, the qualifications for SSI and SSI Medicaid, because there's a lot of different Medicaid programs, but the qualifications are based off of the parent's income and assets under age 18. Over age 18, it's based off of the child's income and assets, not the parents. Even if the child's under guardianship, even if you claim them on the tax return, even if they live in your house, if they're over 18, it's based off of their income and assets. So it's important to note that. And so I want everybody to understand that a lot of times, and I can't speak for everybody, there's a lot of people on here today, but oftentimes families may make too much money or have too much assets. I mean, having more than one car could be too much of an asset, right? Having more than 2,000. There is a such thing as family limits, and it goes up to 5,000. And I don't have that on the slide, it's in a different presentation, but it's like 2,000, 3,000, 4,000, 5,000, depending on the dependents, if the person is under age 18 as far as the asset limits are concerned. But one important thing I want to note is, number one, if a person is getting a Medicaid waiver, we're told that there's like 109 Medicaid programs in Texas, so it makes it confusing. But Medicaid waivers are their own eligibility and criteria, and it differs from the Social Security Administration. So it's important to note that. And then also, sometimes people erroneously do not sign up for Medicaid waivers or put their child on the list because they say we make too much, we won't qualify. But the thing you got to know on the Medicaid waivers, it's based off of the kid's assets and income, not yours, even if they're a minor. So it does matter. And then the last question that we had is about what about family, I think it was family maximums. There is a such thing as family maximums with the disabled adult child, like when the parents are getting Social Security and then the child is getting, childhood disability benefits under a parent's record. And sometimes families have more than one child with a disability. There is a such thing of family maximums with the Social Security Administration. And if you Google it, they're going to say on their website 150 to 188% of the full retirement age benefit. And so it's a complicated calculation. They do explain that on the website, so it's not exactly 100%. So I just wanted to mention that. I'll check in on the chat box with the other things, and then we're going to let Rachel continue on that. But those were just a few important factors I think we should talk about.
Definitely. All right, on the next slide. So benefits are not the only reason for getting a special needs trust. That's a main reason a lot of people get a special needs trust, but it provides flexibility for your child with disabilities. So say that you have a high functioning child, you're not sure if they're going to qualify for government benefits or not, but there's a possibility that they may. If they are not on government benefits, then the trust will operate as a typical trust. So distributions will be made for their health, education, maintenance, and support. A lot of my families that aren't necessarily sure if they're going to be on government benefits or not still like this because the child is not the one in charge of the money. So they have someone else helping out that child, managing distributions for them, and they can help grow those assets and save that money over the lifetime of that child. It also gives some asset protection for them so that if that child with disabilities is potentially subject to being taken advantage of, that they still have a pot of money that they can have used. The big thing with this is that the child with disabilities can never be their own trustee for a special needs trust. So no matter what, they will not be able to be their own trustee, but there's flexibility in the trusts that are built in. Next slide, please. So there is generally two types of special needs trusts. You've probably heard of the second type, which is a third party special needs trust. A first party special needs trust is created with the individual with disabilities' own money. It can be from inheritances if it was outright, meaning the parents did not do estate planning, it just goes directly to that child. It could be from child support or the child with disabilities' own savings. The big thing, because it is the individual with disabilities, their own money, there is a Medicaid payback provision. So after the child with disabilities passes away, any money that Medicaid has spent on them during their entire life will be owed back to that state. So say it's Texas Medicaid, they lived in Texas all their life. Whatever Texas has paid out for Medicaid purposes, they will have to have that money paid back to them before it goes to the other beneficiaries. And in a lot of cases, especially if you're on a Medicaid waiver, this can be a large amount of money. So it's not an ideal situation, but a lot of our cases, we have to do a first party trust. Now, with a third party trust, there is no Medicaid payback provision. So on the next slide, it says that a third party trust is created with someone else's own money. It's anyone else other than the individual with disabilities. This can be parents, siblings, someone with like grandparents, it could be a friend, anyone. There's no Medicaid payback provision for this type of trust. And generally, when we're talking about estate planning, we're talking about doing a third party special needs trust. Next slide, please. All right, now how does this money go from the special needs, or how does it get into the special needs trust? Generally, these are the main ways that they get into the trust. The first one is your will explicitly says that the portion for my child with disabilities is going into their special needs trust. It could also be beneficiary designations. We talked about how important those are. It can say on the life insurance policy that that proceeds, that 1/3, that half of the life insurance policy is going to the special needs trust for that child. They can also be for the retirement accounts that it goes to your child with disabilities. There are some additional advantages with doing that, which I don't have time to get into today, but the retirement accounts can also go to your children with disabilities. It can be a gift. So a lot of times this is whenever it's grandparents, they want to leave a gift to the child with disabilities. They can make a gift where it goes into the special needs trust. And then there's child support. So let's go to the next slide because child support's a little bit unique.
I want to just talk about a special needs trust and a family home being sold. We've got that in the chat box. Home is being sold, and proceeds are going to be divided to the children. One is on SSI. Would this be where their portion should be safeguarded in a special needs trust to preserve that eligibility?
Yes, that's what I would recommend, that proceeds goes into a special needs trust.
But I do want to warn on this that if the kid is a minor, the proceeds that you get from the sale of the home would be counted as an asset. So when that comes in, it would be counted as an asset if the kid is a minor, and they may disqualify for SSI for that period of time. So there may be further discussion needed depending on your unique.
All right, so with child support, this is a unique situation. So if you are a parent of someone with disabilities, I strongly recommend that you pay attention to this just in case this ever comes up to you. So child support in Texas for a person with disabilities can be ordered indefinitely after age 18. If that is the case, after age 18, any child support that goes to that child is going to be considered their own income. Because it is their own income, it will count against them. It will cause a loss of SSI and Medicaid, either a reduction or a total loss, depending on how much that money is coming in. To avoid having this loss of benefits, the divorce decree must order that child support is paid into a special needs trust. It has to be a first party special needs trust. So if you are in the process of getting divorced, if you have lifetime child support, I recommend that you make sure it is actually being paid into a special needs trust. You can go in to modify this if you need to, but the best option is to get everything resolved during the actual divorce proceedings. So just a heads up, it's a unique circumstance, but it does need to go into a first party trust.
Just a quick commercial on that. We hope that you're not going through that, but if you do, to Rachel's point, from a financial perspective, it's easier to get this right on the front end when you're doing this than to go back to the well and have to spend a lot more money on the back end. It is really, really important, and sometimes this is a reason why an individual will not qualify for SSI and Medicaid, so it does matter. And then furthermore, I just wanted to mention that there are specific, we have done webinars on this. You can check this out on the Consolidated Planning Group YouTube channel. There are specific attorneys that are specifically divorce attorneys. So like the Weeks Law Firm doesn't do divorce. They're estate planning, they're doing the special needs trust, guardianship, like what we're talking about. But there are specific family law attorneys that are nuanced with people for people with disabilities that help get these things set up correctly. So if you are in the midst or on the horizon of a special needs divorce, reach out. We'll be happy to make some referrals, but we do recommend that you choose the right attorney that does have some background and understanding on how this all works, so that way that'll help you get it set up right on the front end.
All right. So what happens if I don't have a special needs trust? This is probably one of the most common questions that I get. These are the kind of three options that people tend to try, and I'm going to talk to you about why I caution against this. So the first one is leaving no inheritance to that child with disabilities. In that case, if they have no inheritance left, they are left with just SSI and Medicaid. Again, that's $967 per month. That is not a lot of money for taking care of that person with disabilities. And I strongly recommend that you do not just leave no inheritance to that child with disabilities. Another option is if you choose to do nothing, then they will inherit outright. If they inherit outright, one of two things will happen. Either they will have to spend down all the inheritance that they receive. Say they get $100,000 as part of their inheritance, they will have to spend it down all the way to the $2,000 limit. They'll be left with just SSI and Medicaid. The other option is they can have those funds be put into a first party trust, but that trust is going to have a Medicaid payback provision. So it's not going to go to the other siblings, the other family members. It's going to go back to pay Texas Medicaid. The other thing that I've heard before that people have asked about is leaving assets to other family members. And that sounds like a great idea in the big scheme of things, that you would leave it to a sibling, they're going to take care of them. You cannot guarantee that that child is going to use that money to use it for their sibling. On top of that, even if they're the best person in the world, what happens if they pass away and that money goes from them to their spouse, and it's not going to your child with disabilities? You cannot guarantee what's going to happen to the money. The best thing to do is to set it up as a special needs trust going specifically to that child. Then you'll know that it's going to be used for them until they pass away.
I couldn't agree with you more on this, and we have seen some real disasters, and we've had real conversations with people saying, listen, my son is amazing and he's definitely going to take care of his sister. And that's not what we're suggesting, that your kids aren't great. I think what we're suggesting in a big way is life happens just like life has happened to you. People die, people get sick, people get divorced, things happen, and then the next thing you know, it's all tied up and it's not going to the person that it's intended to. So it is so critically important to just set it up correctly, and then everything goes the way that you had planned. The only thing that we can be for certain is that life is uncertain, and so we can't plan on that for sure. And we couldn't plan that if the sibling did pass away, that the spouse, even though they're great as well, would take on that responsibility. We just don't know that. So it's so important.
All right, so we're going to transition over to talking about guardianship. I'm also going to be talking about some less restrictive alternatives, so we're going to be talking about all of that today. Generally, guardianship is what happens after your child turns 18, and we're looking at, are they able to take care of themselves? So whenever your child is under 18, any child is under age 18, the parents are the one handling money, handling their doctor's appointments, setting their prescriptions, making choices about education, housing, food. Every decision that they're going to make, it is all on the parents. Now, after someone turns 18, they all get the ability to make their own decisions. They are able to open up a credit card, sign a lease, sign education loans, decide everything with their residents, their medical care, everything. With our young adults with disabilities, they may be vulnerable to predators. They may not understand fully what that looks like and who's asking them for money. They may not be able to make those decisions whatsoever. So guardianship is the process where we try and decide what is the best option for that person with disabilities. Next slide, please. So generally, we're looking at if the child is not able to make the decisions needed to care for themselves, if they are unable to make their own medical decisions, or they're unable to manage their own finances, they need assistance in evaluating and communicating all these decisions, or they just need someone to make those decisions for them. They're unable to communicate them whatsoever. We have to at least consider guardianship or consider these less restrictive alternatives as an option for them.
Rachel, this is kind of a big question, and I know that we're in Texas, and mostly Texans are tuned in today, and it'll go on our YouTube channel, and then other people will tune in from other states. And guardianship is very specific to the state that you're in. So I just want to make clear that we are talking about Texas today. And in Texas, it's the least restrictive, most appropriate for the ward is the wording that is commonly used. But there is a growing issue of people taking the least restrictive to the extreme, where a person is not under guardianship that clearly does not have capacity and maybe should be under guardianship or partial guardianship. And there are issues with that. So the first thing that I want to say is that it's important to just work with an attorney. You don't have to know what you need when you go sit down with them. They're going to talk to the individual, they're going to talk to you, and they're going to go through the process of determining what is the least restrictive but underscore most appropriate for that individual. Because I think sometimes people avoid going to sit down with a firm because they're nervous about it. It's a big deal and they don't even know what they need, and so they feel a little gun shy about that. So I always say don't be nervous about it, but I also want to caution against just having your child sign a power of attorney, a healthcare power of attorney, and supported decision-making agreement when clearly they do not have capacity to understand what they're signing, because most kids, if asked, would sign if a parent asked them to sign something. But when the rubber meets the road, when there's a crisis, there's a major issue going on, it could be problematic if they determine that that person never had capacity. So I want to make sure that when we're kind of talking about the lesser restrictive, and I'm not pro or against, I am pro whatever is the right fit for that specific individual. And you might have 5 friends that have the same diagnosis as your child, but your child's functionality is vastly different. So I just think it's important to note this, because I think we've been going one direction and it could be problematic.
And one thing I ask all my clients this, I look at financial and medical decisions, it's very broad. So the questions I generally ask are, could they understand a legal document? Could they sign a lease? Could they use a credit card and be able to pay off that credit card? That's the financial transactions. Could they budget their money? That's the general things that we're thinking about. Or do they just need assistance in those skills? Then you can assist them, and that's a great way to look at it. With medical decisions, the things I look at is, if they are having to have a major surgery and they have to consent to that surgery, would they understand what the doctors are saying, or they just go along with what the doctor's saying? Are they going to look at prescriptions. Should I take this prescription or not? Are they going to be able to ask the right questions, or do they need assistance in asking those questions? And then are they able to manage smaller things like taking their prescriptions every single day, maybe managing if they have a scratch on them that they're seeking for help. You can think about all of those things going into a meeting with an attorney, and we can help you, guide you in that discussion, because there's no one size fits all answer for this. I have clients that think they're going to go one way and they go completely different after we have a conversation. And that's what we're here for, is to figure out what's the best for your child. Now, if you're doing guardianship, a guardianship is a court-created relationship between the ward and the guardian. So the person that needs help, or the person with disabilities, is the ward, or proposed ward is another term that you're going to hear me say. Then the person that gives help is the guardian. Typically, this is a parent-child relationship. It can be siblings, it can be family friends, whatever that looks like, but it's the ward and the guardian. Now, the court decides if the proposed ward is unable to manage their personal or financial affairs. So ultimately, it's not up to the attorneys, it's up to the judge in their decision making. Now, they're going to look at medical and financial decision making. That's what they're basing that decision on, but that's what they're making the final decision. Now, if the court decides that they're not able to manage their own affairs, it will appoint a guardian or potentially co-guardian and take away the civil rights of that person with disabilities. They're really looking at daily decisions that they have to make, and it's going to be a substituted decision making, meaning that the guardian is the one that makes the decision, not the person with disabilities. Next slide, please. All right, now we talked a little bit about public policy. There is a growing legal trend away from guardianship. The biggest thing, other than what we've already talked about, is that because there's this legal trend away from guardianship, there's more stringent requirements or more stringent standards whenever you're actually applying for guardianship. So an example of this is guardianship is no longer assumed if your child is in special education. And another example on how this is more stringent is there's an additional training and a background check that has to be performed on every single guardian that's going through this guardianship process. Next slide, please. Now, there's two different types of guardianship. So the main one that a lot of people have is called guardian of the person. A guardian of the person makes medical and living arrangement decisions for the proposed ward. They're really looking at the day-to-day decision-making abilities for that person. They're going to make medical decisions. They're going to decide where they live. They have to do an annual report to the court every single year. There's also a guardian of the estate. So a guardian of the estate, if that person with disabilities has assets, generally they're looking at more than $2,000. It can go a little bit higher than that, but they're going to handle the property and finances of the person if they have assets. If you are a guardian of the estate, there's additional reporting. They have to do an annual report and an annual accounting to the court. Remember that because the court creates this relationship, the court is monitoring the relationship as we go along. Next slide, please. Now, within the types of guardianships, there is partial guardianship, temporary guardianship, and total guardianship. So a temporary guardianship is more of an emergency action where something has to be done or in order to protect the person or their money, their finances. It's for a very short, limited period of time. Most likely you'll be looking at total versus partial guardianship. So a total guardianship, the ward retains no rights. The guardian makes every single decision. With a partial guardianship, the proposed ward retains some specific rights. Now, you can apply for a lot of different things. The big ones that are generally retained are the right to drive, vote, marry, and to determine where they're going to live, choose their personal residence. It can be one of those things or it can be multiple of those things. But now that we have a good overview of what guardianship looks like, let's talk about some less restrictive alternatives. Next slide, please. All right, so less restrictive alternatives. The goal is to allow the person with disabilities to be as independent and self-reliant as possible. The main ways that these occur, so with guardian of the person, they have a medical power of attorney. And we usually also do a HIPAA authorization. So the medical power of attorney agent, the person with the disabilities is making all medical decisions for themselves if they're determined to be incapacitated, usually meaning that they cannot communicate, maybe they're under anesthesia for surgery, then the medical power of attorney is the one that makes that decision. We also do a durable power of attorney. This allows for the person with disabilities, they can manage their own bank accounts, manage everything they need to do, but the person that has the durable power of attorney can also manage those decisions for them. They can access their bank accounts, pay bills, things like that. We're going to talk about supported decision making in the next slide, but we'll get there. Now with guardian of the estate, typically if you're a child with disabilities, they're receiving SSI, they have low assets, low resources, they do not need a guardianship of the estate. Now, there's some exceptions to that, but the reason why is that they have a representative payee for the Social Security check. So that's the person that's receiving the money for them, that they're going to spend that money for the benefit of that person with disabilities. That's the only thing that they have coming in. Then if they have any inheritances, anything like that, the special needs trust, that trustee, it's an alternative to having a guardian of the estate. Some families also have a joint checking account so that they can have access and the child also has access to that guardianship, that bank account, and then they don't need a guardianship of the estate. Now,
Didn't they change something in Texas? Like, so I want to talk about this because some states do this differently. Some states, like simultaneously, they do the guardianship of the estate and the guardianship of the person. They do it simultaneously. I'm thinking like of California, maybe, some of the other states. But we don't really do it like that in Texas. And I know that they upped this limit. That there's like a certain limit, and I don't remember is it 20,000? I don't remember what it went up to.
yes. So the guardian of the person can manage $20,000 for the person with disabilities. The exemption to that is they have to have a bond on file with the court for that $20,000 amount.
And
So
then for most people, they're not going to have that anyway outside of a special needs trust or an ABLE account because they're trying to maintain eligibility for those state and federally funded programs. And as long as that money, even over the 20,000, is in an ABLE account or a special needs trust, then you don't need the guardianship of the estate in the state of Texas. Is that correct?
that is correct.
Okay. I just wanted to get down to that because sometimes people have moved here from other states and they're confused the way we do it here. It's a little bit different.
Yeah, I will say the majority of my clients do not have guardian of the estate. Most of them are just guardian of the person.
We have another question. Will the will and trust be able to handle or overseas assets, real estate, bank account? Will the will and trust be able to deal with guardianship situations if the family will need to move to another country? So guardianship in Texas is per like by county, right? So even if you move counties, you need to update your paperwork, right?
That's correct. For specific overseas situations, it really depends on the country. So every situation is a little bit different, and you usually talk to your attorney, let them know in advance, and they'll try and do some research. So they coming into the meeting. Generally, with wills, it covers the property that's located in the United States. It doesn't usually cover the stuff outside of the state or outside of the country, but it depends on the jurisdiction and what treaties we have with that country.
Okay, another question that we have is there was two questions about cars. If a person owns a car and and the person is under guardianship, are they required to have guardian of the estate of the car? And really not really, because in any example with Medicaid and SSI, the disabled individual could have one house and one car. I mean, they could be rolling around in a $200,000 car. It doesn't matter the value of the car. So that wouldn't require a guardianship of the estate. Is that correct?
I believe so. It does depend on the specific court. So some of the rules are more gray, and that's one of the more gray area rules. So it depends on that specific judge if they think that they need an additional bond or something in place because of that car's value.
Okay. And then the other thing, do I need the guardian of the state for the car to be in the child with the disability's name? And I've seen it go both ways. I've seen it be in the individual's name with a disability. I've seen it in the parent's name for the benefit of said person. I've seen it be in the special needs trust name to protect the individual from somebody taking advantage of them. I mean, I think that there are different benefits and pitfalls to all of those, and I think a careful conversation on all of that is necessary. And I think it also depends on the person's capacity.
I agree. All right. So let's talk about supported decision making. So supported decision making, it's about 10 years old at this point. You may have heard of it. A lot of people outside of the special needs community have never heard of supported decision making. So I want you to have that caution going into having one of those agreements. But the person with a disability chooses a supporter that they trust. Now, the person that's, I call them the decider, then you have the supporter, which is usually parents or siblings. The supporter is there to help them gather information, ask questions, and really understand the risks and benefits of different decisions. That can be over a variety of different things. It can be over living arrangements. I see this a lot in educational contexts. It could be supports and services, what therapies they have, medical decision making, where they want to work. It can be a variety of different things. How this works in practice is the supporter communicates with the person with disabilities or the decider. The decider is the one that makes the decision. So it has to be their decision, but the supporter communicates that decision to other individuals. There is a state standard form it's notarized by the supporter and the decider. But the important thing is the person with disabilities has to truly understand the risks and benefits of different decisions, and they have to be the one making the decision. Otherwise, this arrangement doesn't work. So just something to keep in mind. It's great in some circumstances, but they really have to understand what it means and make their own decision one way or the other.
And Rachel, while the supported decision-making agreement is great, it's not a thing in every state. A lot of states have a supported decision-making agreement, but not all states. We really like to see this to go alongside of a power of attorney, healthcare power of attorney, HIPAA release, and maybe even an educational power of attorney if the student is going to remain in school. It's helpful to have those documents. But what I want to be clear on, and this is important, the individual that signs these documents, these lesser restrictive options, reserves the right to revoke these documents at any moment. So in some situations, we've seen adversarial parent, child, teenager, situations to where that kind of thing. Now, most of them at that age, they don't know that they could revoke it, but they could at any time. And so if that person is a threat to themselves or others, or if there's other extenuating circumstances, you do want to have careful conversations with your attorney about that, because that is a real factor. And basically all of these things are like, if a person dies and everything like that, it's over. Like, these documents are done.
Yeah, and it really is great in a lot of different situations, but you have to know the different downsides because sometimes it's not recognized. So you have to know really what is it going to look like when I'm using it in practice. All right, let's go to the next slide. So advantages and disadvantages of the supported decision making. So the child's rights are not curtailed. They're able to make their own decisions. They're in control. And they're able to have a lot more freedom and independence, which is wonderful. We want to support that and have that with people with disabilities. However, there is no court supervision of this document. So there's a potential for conflict and abuse. You also cannot really force someone to honor it. And we've had issues with different institutions never hearing of this document before. So there's a lot of educational input with this, using this as well. It may not provide enough care and protection for your child with disabilities. One thing I do want to mention before we switch over to the powers of guardians is that with these less restrictive alternatives in Texas, you're not penalized by trying this first. You can try it first and then go for guardianship if that's the right thing for your child.
And on top of that, like, if somebody is listening today and you have a 26-year-old and you heard that you could start this process 6 months prior to them turning 18, you're not too late. You can have these conversations anytime, so don't beat yourself up on that. We had an early question, and it said, "Hi, I'm considering setting up a supported decision-making agreement with my son once he turns 18. We are not considering guardianship. Will this allow me to be able to speak with his physician and access to his medical records, or will I need a separate legal document for that?"
So for that, you would need a separate legal document. You need a HIPAA authorization in order to speak with his doctors and then speak with and actually gain access to the medical information. They have to sign that as well, which is why we usually do powers of attorney, the HIPAA, and then supported decision making if we're going to do less restrictive alternatives.
And I also just wanted to mention, when we are, talking about the power of attorney and HIPAA release and healthcare power of attorney, that kind of thing, we're always talking about our loved one with a disability, but this really applies to your other kids that you're sending off to college, other adult children. And it's really important to have these intentional conversations with aging family members in your life as well. Because a lot of times people don't have the documents in place, they can't find them, they were done 15 or 20 years ago, they haven't been updated. So it's really important to be looking at this for everybody in the household, not just your loved one with a disability.
All right, so wrapping up real quick so we have some time for questions. Generally, guardian of the person, their job is day-to-day care. So where do they live, medical treatment, where do they work, where do they go to education, where do they get that? Is that something where you have school? Are they going to continue through school until 21? Those decisions. And they also determine who has access to the proposed ward. For guardian of the estate, they're handling all the money, all the finances. They can sell property with court approval, and they can enter into contracts for that person with disabilities. Next slide, please. The important thing is what the guardian cannot do. So a guardian does not place a ward in a mental facility if there is mental health issues. That is a separate court proceeding. It's not related to guardianship. They cannot force someone to take medication. So they cannot control all of that. They also do not take responsibility for any illegal actions of that proposed ward. But ultimately, the big thing is a guardian doesn't truly protect the ward from bad decisions. It says they cannot make those decisions, and maybe you can get out of that in certain circumstances, but you can't really protect them from everything. And then on the next slide, we talked about this a little bit already, but guardian of the person, there's an annual report that you have to fill out every year. Guardian of the estate, there's an annual accounting. So there's a little bit more requirements as part of all of this. Now I'm gonna skip the next slide. We just talked about this a little bit. Is guardianship appropriate? Really look at if there's alternatives to meet the needs for that person, and have I done everything possible to make sure they have independence while still protecting for them. Now the next slide, just as a wrap up for you, when do I need to create a special needs trust or do a guardianship? So for a special needs trust, it's prior to your death or disability, not related at all to guardianship, although a lot of my families are doing this around the time of guardianship. Typically, it's whenever you're ready to have those conversations. And then for guardianship, you can start as early as 6 months before the 18th birthday. The hearing cannot happen until 6 weeks before the 18th birthday or after the 18th birthday, but it's not too late if your child is 26, 30, you can still do guardianship. Ultimately, the goal of all of this is to have a plan in place for your child with disabilities so that you're comfortable and you know that they're going to be taken care of after you pass away. All right, and then I think we might have a time for a tiny bit of questions.
And we've taken the chat box has been awesome today, and a lot of great questions in the chat box. I'm going to just go over a couple of the questions. I've put Rachel's contact information is in the chat box, and again, everybody is going to get a copy of today's slides and a link to the recording, so that way that you guys have that for your reference when you're looking back. Can you give us the generalized cost? And I know you can't speak for other firms. What is the average cost of a non-contested guardianship? What is the average cost of setting up a special needs trust just give us a range.
Yeah, so generally it depends on the county, and you can always call the attorney to ask for an estimate. Generally, they start at around 3,750 to maybe $5,000 for guardianship, for non-contested. And then for setting up a special needs trust, it depends on if you're doing estate planning documents as well. Generally, it's about $5,000 for our firm for the special needs trust for all the things we have to do. And then if you do estate planning with us, we give you a discount on that. So if you,
And
depending
I
on
would say I've seen that range be from 3,500 to in excess of 10 grand. So
yeah.
you guys are really, right in line with where it should be. And it's good to plan that. It's good to know. We had two people. One lady was 86 and one lady was 88. Both are guardians of one as a child, one as a grandchild or whatever, and they realize that they're getting older and not feeling as great as they once did, and they want to get the guardianship changed to where there might be a joint guardian or update the successor guardian. So in that example, they would just need to meet with an attorney to kind of talk through that and get that going. And I would just like to say, yay you for thinking about that. Don't wait till the crisis happens, till something major happens, and then we're a day late and a dollar short. It can still be fixed. Don't worry. But I'm just glad that you guys are thinking about that now. Some people are looking for contacts. Rachel's contact information will be in here. We have lots of contacts depending on where you are in the state, and they do work over Zoom and things like that. So no matter where you are in the state, when it comes to setting up, the special needs trust and things like that, their firm can work with you. You guys are limited to some of the counties for guardianship. That's kind of a different ball game, but we can all make referrals for that. Correct?
Correct. So we do
Okay.
Dallas, Collin, and Denton.
Say that one more time, please.
We do Dallas, Collin, and Denton for guardianships.
Okay. One person said, can my son still qualify for SSI? Can they get SSI back? And the answer is yes, you can. It's a process. You can reach out. Again, we're nationally certified as Social Security advisors. We can definitely help you in that department. This is a QR code. We always offer free personalized consultations at CPG. So if you had questions that didn't get answered today, we can take a deeper dive with you. As always, Rachel, you are awesome. And all of our attendees had great questions. And I think we had a very alive chat box today. So thank you for that. You have really provided a lot of information. And guys, I just want to say sometimes we intentionally try to pack a lot of information in a short period of time when we do these webinars, because we know your time is valuable and we want you to get a lot out of it. We want you to get 1 to 3 nuggets that you take away and you are smarter for attending and you know more and you can help navigate better in your journey with your loved one. But we do realize that this is a lot of information, so that is why we send the recording, that is why we send the slides, and it is why we're happy to meet with you for a one-on-one consultation. So thanks so much, everybody. I hope you guys have a great day, and we'll look forward to connecting with you again and the Weeks Law Firm again soon. Take care.
Thank you.
Bye now.